Hi everyone, and thanks for joining me for this webinar about working in conveyancing. My name is Javita, and I am part of the regulatory education team at New South Wales Fair Trading. In this video, I will be taking you through the conveyancing rules of conduct for a licensed conveyancer. We'll cover the rules set out in the Schedule 2 of the Conveyancers Licensing Regulation 2021. It is important to point out that the information provided in this video is general in nature and is not to be considered as legal interpretation or legal advice. New South Wales Fair Trading acknowledges the traditional custodians of the lands where we work and live. We celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. We extend that acknowledgement of respect to the custodians for the lands on which you're watching this webinar. As a conveyancer, you need to have an understanding of the relevant laws and regulations to be able to carry out your duties. Schedule 2 of the Conveyancers Licensing Regulation 2021 sets out the rules of conduct licensed conveyancers must follow. Breaking these is an offence and can result in licensed conveyancers being penalised or being subject to disciplinary action. In this webinar, I will take you through the rules of conduct governing licensed conveyancers. As a conveyancer, you must be honest, fair, and professional. You must perform your functions with reasonable skill, care, and diligence and never misinform, mislead, or deceive any parties involved. You must comply with your fiduciary obligations at all times. You must not offer gifts, favor, or benefits to get clients on board, and this includes to a real estate agent. You must act in the client's best interest at all times. This means only accepting work that you are capable and competent to complete within an agreed timeframe. If you are not able to complete the required work, the relationship can be terminated if both you and the client agree to it. The client terminates the services and you provide the client with 14 days written notice of the need to terminate. Clear and consistent communication is key to maintaining a professional relationship with the client. Regular updates on the progress of their matter help it manage expectations, build trust, and demonstrates your commitment to their needs. Where verbal discussions are had between parties, you should confirm the discussions in writing as soon as possible. Confirming verbal discussions in writing is not only good practice, but also provides a clear record of agreements and instructions, reducing the risk of misunderstandings. Effective communication not only enhances your professionalism, but also ensures compliance with your obligations as a licensed conveyancer. Conflicts of interest must be avoided. You cannot accept work or continue to fulfill work if doing so places your interest in conflict with the client's. If you have information from a former client that could harm them if shared with a new client, you can't represent the new client unless you get written consent from the former. A conveyancer can represent multiple parties in a single transaction if everyone is informed in writing and written consent is received. If you cannot represent everyone involved without any conflicting interests, then you must stop acting for everyone involved. It's important to point out if you represent both parties in a transaction and a claim is made on your professional indemnity insurance, the excess will increase. The standard excess is $5,000 per claim, but if you're acting for both the seller and a purchaser, this could rise to a higher excess of $10,000. A conveyancer needs to keep and maintain written records of important communications with their clients. This includes instructions received and advice given, as well as any relevant phone conversations and inquiries. These records should be kept with the client's documents for at least 7 years. You can also maintain these records electronically as long as they can be printed in a clear and permanent form in English. There may be situations where you need to refer a client to a service provider such as a building or pest inspector, surveyor, mortgage broker, or another conveyancer. In these circumstances, it is important that you do not falsify or represent that the service provider is independent of you. A service provider is considered independent if you are the conveyancer, receive no rebates, commissions, or benefits for referring a client to them, and you do not have a personal or commercial relationship with them. For example, the service provider is not a member of your family, or you are not in a business relationship with them. If the provider is not independent of you, you must disclose to your client the nature of any relationship and the nature of any rebates, commissions, or benefits you receive. If you own a conveyancing business and you intend to transfer the whole or a part of the business to another conveyancer or solicitor, you must give each of your clients 14 days written notice of your intention to transfer a client's documents and money held in a trust account to the new conveyancer or solicitor. Conducting another business. If you as a conveyancer run another business alongside your conveyancing business, you must ensure that the other business does not conflict with your duties to your clients. You must keep separate files, records, and accounts for both businesses and cease acting for any clients if the other business conflicts with their interests. For example, if you also operate as a mortgage broker, you must ensure that your conveyancing services do not influence or create any bias in the mortgage advice you provide. If a client seeks both conveyancing and mortgage services, you must disclose the potential conflict of interest, ensuring you obtain their written consent. If a conflict of interest occurs, you must stop acting for that client in either role. You're considered to be running another business if you or an associate has material control over the business, receive a substantial income from the business, or have legal or equity interest in the business's assets. When advising clients on loan or security documents, a conveyancer needs to provide clear and thorough guidance. This includes informing signatories about their responsibilities and potential liabilities. You cannot represent any lender in the transaction that relate to the loan or security documents, and if there are conflicts between any parties, then you should not be giving advice. It's also important for conveyancers to communicate that they are not qualified to provide financial advice and that signatories should seek guidance from a financial professional should they have any questions. This means that everyone fully understands the implications of their commitments under the loan agreements, and for borrowers and guarantors receiving independent advice, written acknowledgement of this advice is required. Overall, thorough communication helps safeguard all parties involved in the loan process. Commitment during your conveyancing work, you must fulfill that commitment effectively and on time unless released by the client or the New South Wales Fair Trading Commissioner. You must not ask another conveyancer or solicitor, their staff, or associates for commitments from a third party who is not involved in the undertakings. Remember, these rules exist to protect you and your clients. For a copy of a relevant act or regulation, go to the New South Wales Legislation's website at www.legislation.nsw.gov.au. For more detailed information on what was presented today, go to the New South Wales Fair Trading website at www.fairtrading.nsw.gov.au or the Australian Institute of Conveyancers New South Wales Division at www.aicnsw.com.au or call 02 9633 1355. Thank you for listening today, and I hope the information has been useful.